respect to item number 10 to 13 of today's list, Lordship, taken the consent of the parties concerned, Lordship, can it be towards the end of this month, Lordship, or end of February, Lordship,
You have four?
for the appellants
Your good name?
M. Das?
Okay, on request made by Mr. M. Das, Leonard Council for the appellants. Last week of February,
Last week of February.
list on 29th
Of late, Lordship.
February.
29th February, Lordship.
Yeah.
Of late.
May I please, Your Lordship?
Hmm.
Lordship, I beg to mention item number 6, Lordship. In this matter, Lordship, today I have filed, Lordship, reply to the affidavit in opposition, Lordship. So it may be checked, Lordship. Obviously.
Item 1 for motion.
Maybe, Your Lordship. My lord, the respondent bank has filed right now the affidavit today, and we'll have to file a counter reply. Or two affidavits they have filed right now. I have received, and the affidavits are not in record, my lord. And in the meantime, my lord, we have complied with the last order that we have paid the total amount of 1,45,000, and the first OTS is completed, my lord. And regarding interest portion, the bank has not given the calculation what amount I will have to pay. And as soon as they will pay, we will pay the interest portion, my lord.
Your Lordship, the compromise itself is under dispute. So, and they have been given in liberty to get the OTS if required, but nobody has turned up. So let the matter be decided as a wholly order.
Okay. Mr. Shamal and the council for petitioners. Praise for how much time?
My lord, 2 weeks time maybe.
Praise for 2
Week.
weeks time. To file reply to the counter filed by the respondent bank staff.
In the meantime, my lord, no notice should be served to.
That has already been.
Of course, it is expert.
This after 2
But-
weeks.
Most of that.
Item 2 for admission.
Lordship, the main arguing counsel, Ms. Madhuchanda Bhattacharya, she is unable to be present here today because of some personal difficulty on her part, Your Lordship. Kindly take up the matter next week with the consent of the other side.
Okay. On request made on behalf of M. Bhattacharya. Bhattacharya.
She's M. Bhattacharya, Your Lordship.
For the respondents 3 and 4.
Yes, Your Lordship.
List after 1 week.
Yes, Your Lordship.
Item 3.
Lordship, matter may pass over for time being, Lordship. Arguing counsel, Mr. H.K. Das is on election court number 13, Lord. One part hard matter is going on.
And senior counsel Mr. Abhi Sharma is also on the way
Lordship may taken up after some time.
after some time, madam.
Or will pass over for the day.
No, madam. The urgent hearing.
Huh?
The urgent hearing.
No, Lordship. Otherwise, Lordship, he is
The urgent
getting
hearing.
salary, Lordship. He has getting posting, Lordship. Everything he has got, Lordship.
On the last occasion, your lordship stated that it would be hard on merit and it would be disposed of by today.
But both your councils are not present. What can we do now?
Yes, senior counsel is on the way. This is the timing, madam.
Item 4.
Actually, in this item, not for Lordship. In this item, there is some development, Lordship. Actually, give us some time, Lordship.
Year 4?
I am for the appellant, Lordship.
Your good name?
M. Gogoi, Lordship.
On request made by M. Gogoi and the counsel for the appellant. List
4 weeks,
after 4 weeks.
Item 5 for orders.
Lordship, in this case, Lordship, almost finalized the pension. It is under consideration of how Lordship, some more time Lordship, already petitioner also know the fact. Lord. Yes, Lordship.
Third MS
Can
M.
we-
Nirula, general counsel for the appellant. On request made by MS R.B. Boral and the government advocate.
2 weeks, Lordship,
List the matter after 2 weeks.
deeply.
Item 6 and 7.
May I please, your lordship.
Please, your lordship. My lord, in this matters, my lord, on behalf of the respondents, my lord, I am led by my lord, learned Advocate General of the state.
Hmm.
He has some personal difficulty for the first half. So may I pay, my lord, for taking up these matters on Monday, my lord, 29th, if it is not inconvenient to my lord.
Lordship,
They are already protected in the interim. That interim can be extended till Monday, my lord.
Yes.
yes, no. Monday, sorry.
And they have also, my lord, today in the morning, my lord, they have filed affidavit in reply in through IS. I have just now received copy. But we are required to go through this, my lord, pleadings.
Sorry. We filed they filed an affidavit. We have filed a reply to it, my lord.
He sent,
Definitely, yes,
AG.
Today morning, my lord,
there
just,
is no problem, my lord.
can it
Let
be
him-
taken on Monday, my lord?
Monday is 29th. 29th, okay. ठीक है, 29th.
But Mr. Didas, let the senior counsel appearing for the, you are appearing for the,
For
My lord, in item number 6, it will be, my lord, for the appellants.
appellant,
for the appellants,
Hmm.
correct? For the
Yes.
applicants.
applicants.
On request made on
Application
behalf of
for
Mr. D. Cycle and its Advocate General Assam, list the matter on 29th.
29th is the pre-bid, 29th. And there is another case, is connected item number 7 also.
Hmm.
All this will be listed together.
Uh-huh.
And there is an interim order passed in item number 7 that will continue, madam.
Interim order passed in WBC number 5946 of 2023 to continue till the next.
Yes.
It will continue till Monday, my lord.
Going to connect.
I'm so obliged.
I'm deeply obliged.
Item 27 from supplementary list.
Lordship, in this matter, R. Mujumdar appears, your Lordship. Kindly the matter may pass up for the time being.
Actually, I've been informed that their order is recalled. That impugn order of 6th of January. That order is recalled by order dated 24. I have given a copy. 24 or not.
Impugned orders.
6-1. Impugn order, Lordship, kindly see the IA. Impugn order is 6-1. This order has been issued after issuance of the interim order. Interim order was 19th of December. Lordship, find it Annexure 1A, page 12. Probably, Lordship, they were not aware about the interim order. So subsequently, after filing this IA, by letter order dated 24th of January, this order is recalled and cancelled. So therefore, this IA may be closed, Lordship, in view of this.
Where is
letter.
the order?
I have given the. I sent it, no? No, this is the Or Lordship, after some time, they have,
We have to.
after some time, after 5 minutes. লাগিব ন?
Item 8 and 9 for hearing.
Please, Your Lordship. I'm praying for some accommodation of 8 and 9, Your Lordship. My senior is on legs in court number 20. He would like to be heard in this matter, Your Lordship. If there's no paucity of time, Your Lordship can fix the matter after some time. Or alternatively, I'll pray for a date. Subject to Your Lordship's convenience.
Who's your senior? MK Chowdhury.
MK Chaudhary, Your Lord.
On request made on behalf of Mr. MK Chowdhury and senior counsel for the petitioner. When do you want?
I'll leave it to Your Lordship's convenience, except for 6-2. Except for 6-2, Your Lordship, all the other dates are fine, Your Lord.
8 February.
I'm grateful.
Item 10 to 13.
Mr. John. Mention.
Item 17.
Item 14. Seventeen is blank, I don't know why.
Item 14 to 16.
Lordship, the issue involved in this matter is pending before the Honorable Supreme Court in an SLP, which is fixed on 16th of March. May I pray this matter may come up post in the first week of April, Lord.
You are appealing for?
I am for respondent number 1, Lord. The
Who
issue is
appears-
regard
Who appears for the appellant?
Union of India, Lordship, for the applicant. The last date also, the similar order was passed by a Lordship. Refer to last date's order.
Okay. Your good name, please?
Dr. A2.
Doctor?
A2D.
Dr. A2T. Learned counsel for the response number 1, correct?
Yes, Lord.
Submits that the issue involving the present writ appeal is pending before the Honorable Supreme Court. And therefore, request that the matter be listed after 6 weeks. 6 weeks? Okay. List the matter. When is it coming up in the Supreme Court?
16th of March.
16th of March.
Yes, Lord.
It's a Saturday.
I'm sorry, 12th of March, Lord.
List the matter on 22nd March.
Thank you. Much obliged.
Item 27.
Also, that order of death was given, Lord. There are details, no? In the second paragraph, third paragraph, in view of the above order of the Honorable High Court, the order number so and so dated 6/1/2024 issued from this office, ordered for prevailing the order that number so and so dated 5/8/2023.
Mr. A. Dekal and counsel for the applicant. Has furnished an order dated 24/1/2024.
Lordship, instead of my name, Lordship, their name may be important because inspector is there from there.
Heard Mr. A. Dekal and counsel for the applicant. Hmm? Heard Mr. A. Dekal and counsel for the applicant. Your good name, please? MS A. Das, then standing counsel, School Education Department, has furnished an order dated 24/1/2024, by which the order dated 6/1/2024 has been recalled and cancelled. Mr. A. Dekal and the counsel for the applicant submits that the present IA may be closed.
There's only one difficulty, Lordship, prior to issuance of this order 24th of January, the inspector of schools by letter dated 19th of January 2024, in reference to the earlier order of 6/1/2024, the applicant is directed to hand over the charge to the respondent.
That
is
will,
Lordship,
that will automatically go.
in view of this order, this letter may not be closed. Lordship.
No, I'm not interfering with that. That will automatically go.
Lodge.
He therefore submits that the present IA has become infructuous. Accordingly, this IA is disposed of as infructuous. The order dated 24/1/2024 is placed on record. And what about this writ appeal?
This will be, Lordship, usual court, it will be listed, Lordship, because the appeal is, Lordship, for hearing after 4 weeks. Obliged, Lord.
Which files? No, 17 is not that. Items 17 is blank.
Item 18.
May I please, Lordship? My lord, the petitioner here, appellant here of my lord, is holding the charge of the principal of. What happened, my lord, while passing the impugn order, the honorable single judge has not taken into consideration the relevant provisions of the service.
Are all
code.
parties represented?
Time for the respondent 6.
1 minute, 1 minute.
Rest of the government responded.
Government has not.
Not Kachar Hills.
Their names are being shown, my lord.
Oh. Then School Education Secretary, you are appealing? Then not Kachar Hills.
They have not done.
Dimahasu.
They have not.
My lord, they have also not filed any affidavit, my lord. They are not interested party.
No, this is not this is a writ appeal, isn't it?
Writ appeal.
So what is the use of? There's
My-
no question of filing an affidavit. Just check up. Who's the standing counsel? NC Hills.
Their names are shown.
Names are shown.
Can we proceed without them?
My lord, yes, my lord. Can be, my lord. Can be proceed.
Yes, school education.
They have issued the order
Who issued the order?
Dimahasa.
Then they may be
They
required
are
to
the
be heard.
necessary party. Allowing me to hold the charge of the principal.
My lord,
New rule.
there, my lord, in other day also they are remaining absent, my.
Who's the standing counsel?
I think RM Das.
Namsuguri is plenty, right? Huh? RM Dutch.
Then we'll list another day.
My lord, matter legal questions, my lord, should be listed in a short date, my lord.
Okay. Heard B. Purgayastal and counsel for the petitioner, for the appellant. Stop. Also heard Mr. MS K. Das, London Standing Council, School Education Department for the respondents 1 and 2. Stop. As well as Mr. A. Shektar, Leonard Council for the respondent number 6.
6.
None appears for the respondents 3, 4, and 5. I public North Kachar Hills Autonomous Council. Stop. Accordingly, when do you want?
My lord, there shall be an observation, my lord. Well, other day they have remained absent, my lord. In the event of the absent in the next day, the matter will be decided on.
When
But
do you want?
after 15th, my lord. After 15th of February.
No, after 15th of
Because,
February, my lord.
before that, I have many cases fixed already.
List on 22nd.
My lord,
Like that.
my lord, I have some problem on 22nd.
Then 27th, my lord.
Yes, 27, my lord.
Problem.
Well, there shall be an observation, my lord. If they are regularly remain absent, my
That
lord.
we'll see, that we'll see.
My
on the
lord,
next day.
in the event of the absent in the next date, my lord, the matter may be decided, my lord. That may be observed, my lord.
In the event, the standing council, North Kachar Hills Autonomous so and so is absent on the next returnable date, this case shall proceed ex parte against them.
My lord. Item 19.
This case was heard on several occasions.
May I please your lordship?
Mm.
Lordship, in this matter, NJ Khatnia, he appears your lordship.
Mm.
He's on legs in other court, your lordship. For the time being, your lordship.
For time being, I have no problem.
Thank you.
Item 20.
May I please? Well, in this case, the dispute is regarding, my lord, locality of the candidate, resident. In 2009, I was appointed as Anganwadi worker. Subsequently, thereafter, my lord, the private respondent has challenged my appointment on the ground that I am not a local resident of that particular center. That was disposed of by the court directing to inquire into the matter. It was inquired into and my appointment is there. Thereafter, again, my lord, without issuing notice, my appointment was terminated. I approached this court. And this honorable court, my lord, while setting aside the termination order directed to inquire into the matter, that was inquired and by my lord, imping order, your lordship will find my appointment was set aside. I have challenged this order before this court, my lord. Initially, there was the stay order and subsequently, my lord, the order upheld and my appointment has gone. Now, therefore, challenging this order, I am before your lordship. Your Lordship kindly peruse page 120. This is the order I have challenged in the writ petition.
Yes.
Page 19 is the imping order,
Page?
19. And page 71 imping in the writ petition. And order of passing the writ petition is page 19.
Hmm?
First, your Lordship kindly peruse page 71 order. This is the order I have imping in the writ petition.
Page?
71. Two order in fact imping, page 71 and 74. First is your 71. Your Lordship will find relevant portion, page 72. My lord, got it.
Hmm.
Page 72, my lord, second paragraph. Whereas, the Lordship got it. Whereas in pursuance with the above order, the district social welfare officer, Morigaon, was directed to inquire into the residential status of Gitanjali Kodlita, the appellant before your Lordship, my lord, under such and such project Morigaon. Peruse the inquiry report submitted by DSO Morigaon. It is revealed from the report that DSO, that is District Social Welfare Officer, Morigaon, that the name of Gitanjali Kolita is not found in the survey register and her residence is not situated within the area of Sunarigaon. This is one of the reasons. And last paragraph, your Lordship kindly pray. This page, last paragraph, last two lines. The Gitanjali Kolita has stated that she applied for Anganwadi worker for Fulbari, but she was called for interview in respect of Sunarigaon. Kindly note it, these two lines. And she was selected and engaged in the center. The finding is, my lord, last paragraph. Whereas from the above fact and material on record, it appears that the name of Gitanjali Kolita is not found in the survey register and her residence is not situated within the area of Sunarigaon, and she was engaged in violation of government guideline for engagement of Anganwadi worker and helper. I am inclined to arrive at a decision to order the CDPO Burbanda project to issue termination letter to Gitanjali Kolita. Accordingly, page 74 termination order was issued by CDPO. Here your Lordship has found, my lord, two things. First, there was a survey conducted, according to them, my repeatedly, my lord, and consistently, my pleading is that no survey as such, I was not informed. That survey was not taken into, I have not given the opportunity to take part in this survey. This is my, this survey, whether it is conducted or not, I have no knowledge. If at all it is conducted, it is beyond my knowledge, behind my back. This is my first submission. This was my first contention. And the second is that your Lordship has found that page 74, it is said that I have applied for 2 posts. And to ascertain whether I have in fact applied for 2 posts, there is an order by this honorable court, by the writ court at the time, to ascertain. This order I have annexed, your Lordship will find. Page 126. To ascertain the correctness of this finding in the page 72 order, the order at all I have applied for 2 posts or not. The Lordship got it, my lord, page 126. Page 126. Here your Lordship will find, shall produce the relevant record. Government was directed to produce relevant record, and relevant record was produced. Then in the imping order, it is categorically stated that, no, this is not correct. My only one application is found in the record, and that is against the post where I have appointed. Your Lordship now kindly peruse the imping order, page 19.
No, what happened after this order? Page 126.
The record received and record was examined. And after examining the record, it reveals that Gitanjali Kalita applied for only one post, not for two posts. So this finding was per se, my lord, incorrect. Only one post. That finding is recorded in the imping order by the my lord, Honorable Single Judge.
Where's the final order?
Page 19. Page 19 it starts. Your lordship will find page 23 relevant paragraph 11, paragraph 11 of page 23 regarding this records. Paragraph 11. The State Council further submits that in the hearing before the director, an incorrect statement was made by the writ petitioner that she had applied for, but this is not my finding, this is not my statement. This is the finding of the director who said that I have applied for two posts. But here it is that the statement was made by the writ petitioner that she has applied for Pulbare, but she was called for interview in respect of Sunarigao, where she was selected. By producing the record of the case, which includes the application of the writ petitioner, it would reveal that the application was meant for Sunarigao 24 Anganwadi Center. Therefore, page 71, the imping order passed by the director was, my lord, out and out incorrect. That I have, it is here, my lord, there is some mistake in findings that I have said no. This your lordship has already perused, my lord. Once again, for the moment, kindly peruse. They say it is the director who said that I have applied for two posts. This is not my statement. Page 72 is there, my lord, categorical. The record reveals that I have, according to the director, that I have applied for two posts. The record came to the High Court. The record was examined. And upon examining the record, it appears that it found that I have applied for only one post. Sunarigao, where I was appointed. So therefore, this particular finding is incorrect. So it has to be, my lord, on that very basis, my lord, this order cannot stand, my lord. But this was affirmed, upheld this order. And the first point is that, my lord, the so-called, my lord, survey. That is my categorical contention that at no point of time, my lord, I am taken into confidence for any survey, my lord. I don't have any knowledge. This is one aspect, my lord. And the learned Single Judge has said, my lord, that I have given only the one line mention that she has been heard. What heard? What material has been produced? Nothing mentioned in the imping order, my lord. Therefore, my lord, mayor using the word if had, is it enough, my lord? Because there is a question of, so my question was that, and my submission was that, my lord, both the private respondent and myself is the resident of the same place. I on the basis of merit got selected and appointed. And it is admitted that they have admitted that in the interview I got more marks than the private respondent. The only question is that, my lord, so I have to substantiate my argument that both the petitioner and the present appellant before your lordship and the private respondent are the resident of same village. I have produced, my lord, voter list of the area, where the name of the both appellant and the private respondent appear in the same area. That was not considered. That voter list, your lordship, kindly enact, peruse. This is also part of the record of this appeal, my lord. I have annexed the entire writ petition with annexer in this appeal, my lord. So my contention was that both of us are the resident of same area, and interview held. In the interview, I appeared only in 24 Sunarigao, not as stated by the director that I applied for two posts. So that was not considered, my lord. This is the first aspect of the matter. And the another most important thing is that, my lord, during the pendency of this appeal, my lord, that they are saying their only case, the government's only case is that in the survey, my name was not there. My husband filed RTI application to collect the survey report. That survey report was, my lord, on the basis of RTI application submitted by my husband, that was furnished to my husband. I have filed a additional affidavit and produced this survey report. Here it appears the name of the both private respondent and the appellant is appeared in the survey report. They have disputed the correctness of the survey report. Your Lordship, for a moment, kindly peruse my affidavit, survey report.
So there's a disputed question of facts.
Yes, my lord.
How can we enter into that?
So that has to be, my lord. My submission and contention was that before the learned single judge that the material I have placed before the director, the document I have placed before the director were not properly considered. Though there needs proper consideration. And only upon proper consideration from those documents, it is not the writ court cannot examine who is the local resident, my lord. That only upon proper consideration of those documents, they should have reached into a final conclusion. But that was not done. But my argument and my contention was not accepted by the writ court, my lord, on single judge. Therefore, I am before your lordship, my lord. Your lordship has gone to the page 71 order only on the basis of, my lord, on the two grounds. The first ground, there was a survey report. And I have relied upon one decision of the my lord, rendered by this honorable court that if any survey is conducted and the person against whom such survey is conducted is not taken into consideration, that cannot be taken as an evidence against that person. That was also not considered, my lord. This, my lord, judgment is also a part of this appeal, my lord. Your lordship, for a moment, kindly consider my affidavit, my lord.
Which affidavit?
Here I have I have filed, my lord, additional affidavit. Here I will not page additional affidavit, my lord. It starts from page 135. Two things, my lord, I have. My lord, got it, my lord, affidavit. First one is, my lord, page 144. Page 144, my lord, got it, my lord. This is a resolution of the selection committee of the which selected the, my lord, who is the responsible for selection of the Anganwadi workers. Selection committee says I am the local resident. This is the resolution. They have disputed it, saying that on what purpose, how that is taken. Their reply is also in the record, my lord. Your lordship, in today's meeting, the field inquiry report submitted by member secretary of the selection committee in terms of resolution accepted in the meeting dated 1/8/12 in respect of Gitanjali Kalita Anganwadi worker of Shunariga Anganwadi Center was examined. In the report, it was mentioned that Shunariga Anganwadi Center is located in the revenue village of Gasbari under ward number 8 of Morigaon town. Shunariga is a hamlet of Gasbari. As mentioned in the report, the house of Gitanjali Kalita was initially located at a distance of 500 meters because at that point of time, the Shunariga Anganwadi Center was temporarily running on a boundary of village Gasbari and Shunariga. It is also mentioned in the report that at present, since the center has its own house, the center is situated at a distance of 700 meters from the house of Gitanjali Kalita. It is also mentioned in the report that the center is at a walking distance of 12 minutes from the house of Kalita. The house of petitioner Biba Goswami, that is the respondent number 6, private respondent, is situated at Shunarigaon. The local Gaubura submitted report on this respect during the time of local inquiry. In today's meeting, the merit list prepared in terms of interview held for the appointment of Anganwadi worker in 2009-10 was examined. During such examination, it found that the name of petitioner Biba Goswami Wanto is appearing at third position in the merit list. On the other hand, Gitanjali Kolita is discharging her duty as Anganwadi worker comfortably, and also she is undergone job training of Anganwadi worker. It is also to be mentioned that Kolita at present discharging her duty with all responsibility as BLO for revision of electoral roll. Therefore, today's meeting unanimously resolved to send the proceeding meeting to the Director Social Welfare Department for taking up the necessary action. So categorically, my lord, they have found both the petitioner, petitioner and the private respondent. It is the official record. And it is also in the record that private respondent is to third in the interview. I am first. Therefore, my lord, the next page your lordship kindly peruse. Page 149.
What is part of the writ petition?
No, that was subsequently because I have said, my lord,
How can you produce this document?
only on the basis that my categorical submission was that, my lord, I did not have any knowledge about this inquiry. And it is only they are saying that at no point of time I was taken into consideration or I am asked to join any such inquiry, my lord. Subsequently, my husband has filed RTI application. On the basis of RTI application, my lord, those documents are furnished. Therefore, with the leave of the court, my lord, I have filed this additional affidavit annexing those two documents, my lord. Your lordship kindly peruse 149, page 149. At house number, my lord, entry number 44, the name of private respondent is there, my lord. Harendra Mohanto, Biba Goswami, and Rohit Mohanto. My lord, got it, my lord. And serial number 87 in the report, my lord. Naren Hazarika, Gitanjali Kolita, and Nihar Hazarika. My family's name appear. So it is not there. It is not after obtaining this document, my lord, on the basis of RTI application of my husband, it is categorically proved that the stand taken by the state respondent that on the basis of, my lord, survey, there is a survey conducted, and on the basis of survey, I found that I am not a local resident. This is appeared to be false, because my contention category, my consistent submission was that, my lord, that at no point of time, if at all I have been asked to join such survey, I didn't have any knowledge about those survey report, my lord. Therefore, I was denying this survey, my lord. And now, subsequently, they have furnished, it is their document, on the basis of RTI, those documents are furnished to my husband, my lord. And it appears that both the name, private respondent name and my name appear in the same place. And they have filed their reply, my lord. What they say is, my lord. You will have to kindly see. In respect against this additional affidavit, my lord. Paragraph 6 of their reply, my lord. This is relevant, my lord. 3 is also relevant. Paragraph 3, page 156. That with regard to the statement made in paragraph 1 of the additional affidavit, the deponent state that deponent does not admit the statement contrary to the relevant record. The appellant may be put to strict proof of the same. Further, the deponent state that the copy of the survey report as annexed by the appellant, that is annexer C to the additional affidavit, is a survey report prepared by the appellant herself while the appellant was working as Anganwadi worker by misusing her official capacity. If it is so, then why that point?
No. This is by the respondent number 6.
Yes.
How about the state respondents? Have you filed your affidavit against this additional affidavit?
We have not filed any affidavit, but we
You'll have to
have
respond to
the report.
this. You'll have to respond to this affidavit.
Yes.
As he is disputing the whole survey, etc., lordship, he has to go civil court because our director has surveyed and found he is not.
No, that's why
Yeah.
he has filed an additional affidavit. You should respond to that additional affidavit.
Lordship, then I need some time to file it.
Yeah, you should respond. You're the main respondent actually.
Yes, sir.
Petitioner and the appellant and the respond number 60 said, of course, they are it's not an issue, but you have to come forward with regard to the additional affidavit filed by the appellant.
Then I need some time to file affidavit, Lordship, because I think that.
It will be next, right?
Record will
That's what you're saying.
suffice, Lord.
But Mr.
Yeah, you did.
Yeah, within the counsel for the petitioner, for the appellant. MS Abi Boral and government advocate. Is allowed, how much time do you require?
3 weeks, Lord.
2 weeks time to file reply. To file reply to the additional affidavit filed by the appellants. List of the 3 weeks.
Okay, I'm appearing as legally counsel, so my presence would be
Okay, MS LDV,
AD.
ADV, Leonard. Legal aid counsel appears for the respond number 6.
May I pray for my date, my lord?
Even a date.
Right.
Give a date after 3 weeks.
After 3 weeks,
21st February.
21st February. It will be okay, madam. I am obliged.
Item 21 and 22.
May I please your worship? Worship, in this matter, already heard by another bench, my lord, and record was also called for, but record is not available, my lord, which registry only, my lord. Already heard by another bench. my
Lordship,
lord.
kindly see order dated 9/1. 9/1 made it part. Order dated 9/1.
Okay.
The next day, my lord, considering the urgency of the matter was fixed on the next day. After hearing the both the sides, my lord, at length, my lord, lordship wanted to peruse the records of the earlier writ petition, which was disposed of by the single bench, my lord, as well as the record to be produced by the, my lord, state.
Okay. List this matter
My lord,
in terms of the order dated 9/1/2024.
my lord, what happened, my lord? Urgency is there because term is already, my lord, finished, my lord. So on 29, my lord, lordship,
That I can't. Let the registry fix it because it's a parted matter.
that is why, my lord.
Yeah. So
And
they will list it accordingly.
Obliged, man.
My lord,
Hmm.
my lord, and considering the urgency of the lordship, may fix a date, my lord. Otherwise, my lord, everything will be infructuous,
Why infructuous?
because the term is
Already over, my lord. Their term is
about to be
already-
over, my lord.
He's saying it's already over.
No, my lord.
When is it getting over?
In terms of the provision of the act, my lord, they have to vacate the office on from their period is 5 years from the date of assuming the office first meeting, made. So first meeting in the month of February, made.
First week of February.
That is why.
In different places, some in January, in some first week of February, my lord.
No, the issue is that the other judge
Yes.
may not be present on 29th.
Yes, my lord.
Yes.
Provided if available, my lord. That, my lord. Then, if he is available here, my lord.
Registry can fix a date, my lord.
My lord.
Registry will
Yes,
fix
yes.
it.
That observation may be there, my lord. That
Al-
Already given, my lord. Already.
lordship will observe
In
that.
terms of the orders, there is so and so on a date to be fixed by the registry.
My lord. Obliged.
It is 21 and 22.
Timing item 19.
May it be the lord. But this is an appeal preferred by the state, my lord. The appeal is directed against the judgment and order dated 22/1/2019, passed in WPC number 1728/2015. The impugn order is at page 125, my lord. The brief facts of the case is that, my lord, the
petitioner filed that's writ petition 1728/2015 claiming for her salary, my lord. According to her, my lord, she was appointed in the year 1999 pursuant to a selection process initiated in the year 1997. And she was initially posted at number 143 Boroma Nimna Bunyadi Vidyalaya, which is under the BTAD area, my lord. Subsequently, she was transferred to, my lord, number 1131 Jolkhana LP School, which is in the general area, beyond BTC, my lord. So, according to her, my lord, she received salary till April 2006. Thereafter, her salary was stopped. It was stopped because it has been found that her appointment was illegal without any recruitment process, my lord. That is why her salary was stopped. So accordingly, she filed a petition. That petition was disposed of, directing to place her case before the expert committee. There was an expert committee to find out the legality and validity of an appointment and their claim for salary. That was placed before the expert committee, but expert committee could not consider their case because entire record pertaining to those selection during the year 97 to 99 was seized by the police due to because of some criminal case, my lord. So finally, my lord, she filed another writ petition that was also disposed of with the same line. Finally, this writ petition was filed, and the learned single judge, without considering the legality of her appointment, direction was issued to pay her salary if she was working. My lord, may kindly come to page 127. This is the operative portion, my lord, paragraph 9. The case projected by the petitioner portrays a very sorry state of affairs. Since the petitioner has been allowed to continue in her service as an assistant teacher, pursuant to her selection and appointment by order dated 4/12/1999, and also paid her salary till April 2006, there cannot be any reason for non-payment of her salary since the month of May 2006 till date. Though this petition was filed in the year 2015, even during the pendency of the petition, no redressal measures were taken to pay the salaries of the petitioner. It is neither the case of the respondents that the petitioner is not discharging her duties as a teacher pursuant to attachment to number 1131 Jolkhana LP School, which is under the general area. The present employment of the petitioner being in the general area, there is no involvement of PTC also. In view of such facts and circumstances, the present petition is disposed of, directing the Director of Elementary Education, Assam, to verify as to whether the petitioner has been discharging her duties as an assistant teacher of so-and-so school, and upon such verification, if it is found that the petitioner is indeed discharging her duties in the said school as an assistant teacher, her salaries, both area and current, should be paid. So, without deciding the validity of the appointment, my lord, direction was issued to pay her salary.
Are you permitting her to function as a teacher?
Yes, my lord. She was working. There is no dispute on that, my lord.
Is still working.
Still working, my lord. She was still working, but there are subsequent development, my lord. That is why this writ appeal was filed, my lord.
What subsequent?
Yes, my lord. While this order was passed, thereafter we have verified her entire case record regarding her appointment and all. During that verification, we found that her initial appointment was illegal. So, in fact, from in the year 89 to 2001, during that period, there are lots of illegal and irregular appointment. This issue came before this honorable court in a writ petition. The honorable court was pleased to constitute a screening committee. Direction was issued to verify all the illegal and irregular appointment. So, department took a decision, cabinet decision, to form a screening committee. And this petitioner, she also participated in the screening committee. And during that screening committee, it has been found that her initial appointment was illegal. So subsequently, she has been accommodated as tutor. A decision was taken by the cabinet. Those who have initial appointment were illegal, but they have continuing their service, they have been accommodated tutor. And she was also accommodated tutor. But she didn't accept that, my lord. The accommodated press appointment, she did not accept it, my lord. So that subsequent fact was brought by way of a review application, my lord. We filed a review, seeking review of this order, my lord, saying that these are the development which were going on during the pendency of the petition, but that could not be brought in record, my lord. So that review was also dismissed. Review order is at my lord page 129, my lord. So this review also, my lord, dismissed. Pursuant that, my lord, we have filed this writ appeal, my lord, challenging this writ court order and review court order, my lord. And during we have also brought in record the decision of the cabinet by way of an additional affidavit, which is at page, my lord, 200. Page 200, my lord. We have filed an additional affidavit to bring a record the decision of the cabinet, my lord, by way of which the petitioner was accommodated as tutor, my lord.
Page 200.
Page 200. Yes, my lord. Here, my lord, page 209 is the cabinet memorandum. This may read, my lord. Subject is a regulation of irregularly and illegally appointed teachers of lower primary and upper primary school by creating supernumerary personnel post. A large number of teachers were appointed irregularly and illegally in lower primary and upper primary school all over the state during the year 1989 and 1991 to 2001. The petitioner was appointed in the year 1999, my lord. So she was also under the same category, my lord. More particularly in Dhemaji, Lakhimpur, Sibsagar, Karimganj, Hailakandi, Bongaigaon, Nalbari, Dibrugarh, Jorhat, Golaghat, Nagaon, Morigaon district. The petitioner belongs to, my lord, Nalbari district. By some field level officer and school managing committee without following the provisions of law laid down in Assam Elementary Educational Provincialization of Service Act 1974 as well as Rules 1997. In terms of the Honorable Court's final order dated 2/3/2010, passed in so-and-so, the Education Department placed the matter of regularization of irregular teachers before the Cabinet in its meeting held on 26/2/2011. With a view to examine the nature of appointment, status of post, working status, status of salaries, academic qualification, etc., the Director of Elementary Education, Assam, invited application from these irregularly, illegally appointed teachers during 1991 to 2001 throughout the state by an advertisement dated 1/2/2012 and 4/2/2012 in the local newspaper. In response to the aforesaid advertisement, applications were received from such category of teachers. After preliminary examination and applications so received by at the directorate level, the Elementary Education Department constituted 5 screening committees headed by the divisional commissioners concerned and principal secretaries of the 6 scheduled areas to examine these applications preliminary committees report. So the petitioner also participated responded to the said advertisement and participated in this screening process, my lord. So after the scrutiny, my lord, these are the following facts noted, my lord. A large number of candidates were appointed on 6/12/1999. The petitioner was appointed on 4/12/1999, my lord, at Sibsagar, Nalbari, and Lakhimpur district, the very day on which a ban on appointment was issued by the government. A substantial number of candidates of Nagaon and Morigaon district were appointed by the school managing committees of school, but according to the provisions laid down on so-and-so, had no power to appoint teachers in provincialized school. All the candidates were appointed against non-existent posts, that is in excess of existing posts. No records regarding appointment, proceeding books, selectives, etc. are available in the district concerned. Most of the irregular teachers were found to be irregular in attendance in their respective schools. Most of the teachers did not receive salary right from their date of joining, and some received salary up to a certain period only. All salaries were discontinued since 2007. Petitioner, her salary was stopped from 2006, my lord, April 2006. Only the teachers of Sibsagar district received salary up to 2012. So after scrutiny, my lord, 4 categories of teachers were identified, my lord. First one is, my lord, recommended and working till date, total number 136. Second category, my lord, recommended but discontinued with the job, total number is, my lord, 250. Not recommended but working till date. And then not recommended but discontinued with the job. The petitioner falls under the category, my lord, not recommended but working till date. So this category of teachers finally accommodated as per their qualification as teacher or tutor, my lord. That finding, my lord, will find in the cabinet approval, my lord. Page 213. After thorough discussion, my lord, 213, last cabinet approval sought as on one-time exceptional measure for the following. Approval sought for
One minute.
accommodating those
213.
213, my lord. Last part of the cabinet memorandum.
Last part.
Yes, my lord. Cabinet approval sought as an one-time exceptional measures for the following. Approval sought for accommodating those teachers who have received salary up to 2007 and have successfully completed their junior basic training DLA course by creating personal supernumerary post with prospective effect from the date of approval of the cabinet. This post will exist as and when the incumbent retires from service. The total number of persons included in the list one is 1574. Approval sought for who received salary up to 2007.
It is not 213, it is 233.
Sorry, my lord, in maybe there may be a mistake in my pagination, my lord.
Last page. Hmm?
So, my lord, the second category of teachers, my lord, approval sought for those who received salary up to 2007 but have not acquired the professional qualification before 2011. So, petitioner was under this category, my lord. She received salary up to 2006, my lord, and she did not completed her professional qualification before 2011. So, pursuant to this cabinet decision, she was accommodated as tutor, my lord. So, that tutor appointment we have annexed in with this petition, my lord, at page 124. This is her fresh appointment, my lord. Page 124.
Hmm? Yes.
This is dated 30th January 2021. So she has been accommodated as tutor with prospective effect. So our basic case is that, my lord, her initial appointment was illegal, and which is established in a fact-finding inquiry, my lord, pursuant to direction of this honorable court. She participated in the screening process. She was identified as illegal, and accordingly, she has been accommodated as tutor, my lord. That is our basic case, my lord. Since her initial appointment was illegal, my lord, she is not entitled for any salary, which is held by this Honorable Supreme Court, my lord. I am relying on a judgment, my lord. Two 2015 SCC 466. Case of State of Bihar versus Devendra Sharma. Para 35, 36, and 37, my lord. If the initial appointment is illegal, my lord, it's not entitled for salary. And she is not denying the fact that she has participated in that screening process.
Read it. Yes.
So my humble submission is, my lord, since her initial appointment was illegal, which was she was identified as illegal teacher by the screening committee, and she is also not disputing her participation in the screening process, my lord.
But then how do we know that she's in that illegal appointment?
Yes, my lord. That is, there is a list in this page 120. 123, my lord. Page 123. The list is there, my lord. Her name at page serial number 8. That is why that order was issued, my lord. Accommodation order was issued, my lord. Oloka Kolita, name of school, my lord, 113 number, Jolkhana LP School, Block Tihu, Boroma. That is the finding whether she received salary or not. Yes. Whether teachers completed her training or not, my lord, no. So on the basis of this list, my lord, she was accommodated as tutor instead of teacher, since she has not completed her training before 2011.
So she's still continuing as
Yes,
tutor?
yes.
Tutor or teacher?
Because
Teacher.
thing is that, my lord, this accommodation order, she did not accept it, my lord.
Why?
Why, I cannot say, my lord, because she did not accept it.
If she did not accept it, then you could have terminated her.
That has not been done till date. Because of this pendency of this petition, perhaps, my lord, department doesn't want to.
When was the appointment given as tutor?
It's 30th January 2021, my lord. With effect from, my lord, from the date of cabinet decision. One 11/2020.
Where is that?
It is in first paragraph, last part, my lord. With prospective effect from 1/11/2020. Sixth line, my lord.
The Lordship will kindly read that she will not be able to claim any salaries for her services. That clause is also
Where?
there.
My lord, line, fifth line from after the chart, my lord, fifth line. The accommodated tutor will get prospective effect from so and so.
And
She cannot claim.
Cannot claim any benefit whatsoever in respect of her past services. That is in violation of the High Court order. High Court says if he is working, she has to be paid salary.
Where's the order?
Which one, my lord?
Single judge?
Single judge order, page
119.
the relevant portion, my lord, paragraph 9.
Yes.
Honorable single judge did not consider the legality and validity of the appointment, my lord. That order was passed on the premise that if she was working, she has to given the salary, my lord. That is the only observation made in that petition. That is why, my lord, we have preferred and review and subsequently this appeal. because her appointment during the pendency of the petition, the screening process was
What
started.
happened to the review? It was dismissed.
It was dismissed, my lord.
On what ground?
There is no specific ground, my lord.
Cost of 50,000.
My lord, may come to the review order, my lord.
Which?
Page 130. Paragraph 8, my lord. So and so learned counsel submits that upon scrutiny, it has been found that the initial appointment of the writ petitioner was not in accordance with law. Further submits that since the initial appointment is not accordance with law, question of payments of salary will arise, and therefore the present case is fit for exercising a review jurisdiction. On the other hand, so and so, the writ petitioner submits that no grounds for review has been made out, and the grounds are very much pleaded facts in the writ petition which were already dealt with by this court while disposing the writ petition. He further submits that the present ground cannot be taken up in as much as the authorities have abandoned the proceeding which was initiated by proposed notice that so and so after submission of reply by the writ petitioner, which would necessarily mean that no irregularity or illegality in the initial appointment of the petitioner. In any case, the learned senior counsel submits that the powers of exercise are to be exercised sparingly, and no such case has been made for such excess of powers. With paragraph 10, my lord, the rival submissions of the learned counsel of the parties have been duly considered. The power of review are to be exercised with utmost care and caution, and only on certain conditions. Though the Code of Civil Procedure as such may not be applicable in a writ proceeding, the spirit is certainly applicable, and as per the same, the conditions for exercising power of review, namely error apparent on the face of the order, discovery of materials which were not within the knowledge of the applicant, and which would have a material bearing in the outcome of the case, even the broad expression of any other sufficient reason are not discernible in the present case. In fact, this court has noticed that no grounds at all have been pleaded for review, as this only ground pleaded regarding the initial appointment was the ground taken up for hearing in the writ petition. As contrary so and so, the said grounds perhaps would not be available, as the process initiated by issuing so-called notice so and so was abandoned by the authorities on their own volition after submission of reply to the so-called notice by the petitioner. It is a settled position of law that mere error of judgment cannot be a ground of review, and the error has to be palpable, one which apparent on the face of the record. No new facts was discovered after passing of the judgment, and above all, the delay in filing the review, and that too after filing of the contempt petition of the writ petition, in which personal appearance was also contemplated, raises serious doubt regarding the bona fide of present application. So, my lord, accordingly, that review was dismissed, my lord.
With cost.
With cost, my lord.
Have you paid the cost?
No, my lord, this order has been stayed, my lord.
Stayed.
Yes. So, the fact regarding her initial appointment, that was not considered by the Honorable Single Judge during the writ proceeding, my lord. That is why, my lord, in fact, Honorable Single Judge in the review petition, it has been observed that it is a settled position of law that mere error of judgment cannot be a ground for review, and the error has to be palpable one, which appear on the face of the record. So there may be some error. That is why, my lord, that review was dismissed, and we have prepared this appeal, my lord. So that ground, obviously, we can take in the appeal, my lord. So, and this judgment of the Honorable Supreme Court that clearly said that, my lord, if the initial appointment is illegal, question of salary doesn't arise. And in the writ petition, my lord, that issue was not decided. Only direction was issued to pay the salary if she was working. So that is my humble submission, my lord.
I think
Yes, my lord.
that the initial appointment was illegal. Apart from the screening committee.
That is the from the screening committee. It has been found, my lord. Screening committee divisional committee was constituted. Those committee verified the documents, my lord.
Where is the finding?
That is the lease, my lord. Finding there is no.
No, forget about the list. Finding. Specific finding of the screening committee.
There is no specific finding because they have verified the document. They prepared a list. On the list, my lord, they have mentioned it, my lord.
Has to be. Come to the conclusion. The finding has to be there.
There is no minutes as such, my lord. As per my knowledge goes, my lord, there is no minutes as such.
Moreover, you have allowed her to continue.
Yes, that is there, my lord.
As
In
a
fact, she is still continuing. She is still continuing. And as regards the screening committee report is concerned, my lord, screening committee, they have called for the documents from the incumbents also, my lord, and from the office also. They have tallied the documents, verified the documents. They prepared a list whether is there any initial advertisement, whether there is select list, whether there is
There are no minutes.
there is no minus access. As per my knowledge goes,
Are
my
you
lord,
sure?
that I have to, but my knowledge goes, my lord, I don't, there is no minus.
Because there has to be something to come to the conclusion that the petitioner's appointment is illegal.
Yes, ma'am.
And therefore his appointment should go in this illegal list.
That I have to confirm, my lord, whether, because whenever I sought for document, my lord, they have given me the list and this.
No, you have filed this writ appeal on
Yes.
the basis of all those findings of the screening committee.
Yes, my lord.
Then there must be some basis. Like
There has to be a
minutes.
basis.
Minutes, I'm not sure, my lord, whether it is there. I can confirm it, my lord, but I'm not sure, my lord.
Yes, the judgment which you have relied
Yes, my lord.
was a clear finding. It was a clear finding. There was no advertisement, all those things.
Here also, my
As per
lord,
the procedure.
finding
There is no sanction post.
is that is there, my lord, and in fact, here also, my lord,
Basis, the finding, basis of the finding, there should be a finding.
that I have to confirm on, my lord.
You check up whether there's some finding.
Yes, my lord.
Unless there's a finding, they can't put the petitioner in this list or that list. Obviously,
We came to know about his tutor, the order offering tutorship only in the affidavit in opposition. Petitioner doesn't know about it. And your lordship will kindly say order dated 3/10/23 by this court.
in this writ appeal.
Yes. And during the pendency of the case, well, there was a direction for paying 5 lakhs rupees that has been paid to the petitioner. 3/10/23.
Have you challenged this appointment?
Appointment order has not been cancelled. That is the
No, this appointment as a tutor.
tutor, my lord, that your lordship will get the 3/10/23. Because my appointment is continuing. That page 53, that appointment letter, 5/3, your lordship will, this order, your lordship will can you see? During the course of argument, Attorney and Learned Standing Counsel Department appearing for the appellants, I'm reading this tutor order, has drawn our attention to the order dated 30/1/21. This is the tutor, whereby the respondent herein has been accommodated afresh as a tutor on purely temporary basis fixed at salary rupees 10,800 per month. The order also recites that the respondent shall not be entitled to claim salary for the past services rendered by her. Mr. So-and-so counsel appearing for the respondent has pointed out that this order is in gross contempt of the orders passed by this court in the earlier rounds of litigation. Submitted that the respondent was appointed by the competent authority as an assistant teacher by the order dated 4/12/99 against a sanctioned vacant post. This order has not been touched by the authorities, madam. He apprised this court that the respondent herein was issued a notice dated so and so, requiring her to show cause as to why her selection as a teacher in a provincialized lower upper primary school should not be cancelled, as the same appear to have been made in violation of the rules. However, it is not in dispute that the notice did not yield any any considered decision cancelling selection appointment of the respondent, and she continues to serve as a teacher till date. Submitted that even as on date, the respondent is serving in the same school where she was initially appointed. Of course, later on she was transferred. However, she is not being paid salary. He further asked that other similarly, 2,272 teachers were appointed. They are being paid regular salary by the state authority. On careful perusal, we note that the order dated 31/21, that is the tutor, does not reflect that the earlier appointment order of the respondent has been cancelled. So we are thus of prima facie view that as the respondent's appointments order dated so and so has not been reversed, recall, the legality of the order dated 31/21 appointing her afresh as a tutor on fixed salary is by itself seriously questioned. Faced with this, Mr. Khatonier prays for an opportunity to place on record the minutes of the scrutiny committee. This is what is placed. The minutes of the scrutiny committee, a committee was there, they say, my lord, irregularly, illegally, petitioners and affected person doesn't know anything about it. Even in this present case, the tutor appointment has come to know the knowledge of the petitioner only from the affidavit filed by the FLN.
Mechanical manner.
Mechanical manner. Therefore, my lord, your lordship will kindly see page 53, my lord. 53, my lord. 2,272 teachers were not getting salary since 2006. Others are now getting under BTAD. And now the question, my lord, 52, my lord, 53. My lord. This is the order of appointment. It's intact. They have issued a show cause, PS 57. This is the order of appointment dated 4/12/99. And page 57 is the show cause. This is the show cause issued. It reveals that you were shown appointed in a teacher in a provincialized lower school. There are no records to show that you were selected so and so. All these are there. Then I have given a reply, page 58. We have submitted all the documents, my lord. Whatever was given, I have given. Then they say, my lord, all these documents were, my lord, seized by the deputy commissioner. That your lordship will find page 80. Page 80, 81. That is the the detail of the report given in the writ petition. Regarding detailed report, I have the honor to inform you that documents of appointments are not available in the office due to seized by the then Deputy Commissioner Nalbari. So genuineness appointment could not be verified. Then thereafter nothing has happened. If the appointment is illegal, my lord, my simple answer is, you see 2,272 teachers are still working. What do you say about it? Now I have given the list of documents of appointment of some of the persons who are still continuing in their service and who are getting salary. That your lordship will get it at page 162. Right? 172, my lord, that salary drawal certificate of some of the petitioners who were like the petition. Some of the persons who were at par with the petition. May I just read, my lord, 163, page 164, my lord, paragraph 2, that reply. One or two reply. May I just read? Paragraph one, page 164, paragraph 2. Well, that deponent respectively states on subsequent occasion, some of the incumbents who were appointed along with the
No, no,
deponent,
164 is a different page.
164, my lord.
It's a type copy.
My lord, type of that additional affidavit, I think, huh? Filed on 11/8/23, my lord.
Additional,
That is additional affidavit.
that starts from page 220.
220.
Hmm.
Maybe my pagination is wrong. I'm sorry, man. Then it will be
Additional affidavit.
24, I think,
One-
124.
Additional affidavit by
By the,
respondent number 1.
yes,
Additional affidavit by respondent number
1 minute.
1.
11/8, my lord.
1 minute, 1 minute.
Pagination तुम को कर सकते
165.
I'm sorry, man. Maybe my lord.
Anyway, meantime you correct the
Yes.
pagination.
160.
Katani, earlier occasion also you were directed.
Yes, my lord.
Yes, yes.
Pursuant thereto, my lord, I have filed that additional affidavit, my lord. Last affidavit, my lord.
That cabinet decision.
Cabinet
which,
decision, I have
So
brought
that,
it.
that part we have seen. Where is the minutes of these?
That, my lord, I could not gather, my lord.
It is not available, my lord. There is nothing.
I have been informed that, my lord, they have
So
just
it is
prepared a
not
list.
there. Are you sure it is not there?
Yes, my lord. Though I have no written instruction, but telephonically, what I have gathered, my lord, that they have just called the documents from the petitioner and from the department of, they have prepared a list, whether the is there advertisement.
I think he should reconfirm, no? Let him reconfirm and come back. Otherwise, he has got no case.
Well, she should make a statement
Mm.
that there is no reference of the screening committee. That should be supposed unless we should find that the appointment was really illegal. They have been allowed to continue.
Why don't you check up and come back?
Yes, my lord. I'll get a written instruction from the department, my lord.
Get it.
I think it will be better, my lord. Is there any
The absence of that,
any minutes is there or not?
you are working on sticky wickets.
My lord, may fix it on Monday, my lord.
Pending for a very long time, man.
Yeah.
Yes, my lord. That is there, my lord. My
And
lord,
the
may fix
same
fix on
issue,
Monday, my
same
lord.
issue arose a lot of earlier occasion when the division bench have passed this order.
No, that part we have seen.
Yeah.
Yes. Okay, and request made by Mr. N.J. Katania, standing council.
Department of School Education.
Based on Monday will be difficult.
Monday or Tuesday, what?
Monday.
Any convenient date, my lord.
30.
30. Yes, my lord.
Tuesday.
Oblige, my lord.
Lord, I have given that page 165, last annexure 8, 9, 10. I have given 3 Supreme Court judgments showing, my lord, if petitioners are working, appointments are intact, you cannot deny select.
Oblige, my lord.
Meantime, we can correct the pagination.
My lord, I'll do it. I'm obliged.
Item 23.
Actually, the youngest council is on lakes. So for the time being,
For the appellant,
for the respondent.
who is
Chair
appearing
for-
for,
chair
who is,
for the-
who's appearing for the appellants? Yeah, for the respondent,
Yes, sir.
none appears for the appellant. Mr.
I'm noticing G Sharma.
Mr. G. Sharma, learned counsel, appears on behalf of the respondents. List after 1 week. Or 2 weeks. 2020.
And 25.
May please your lordship, both the matters I pray for adjournment, lordship. Taken the
Yeah, for the appellant.
in
I am a
24, I am respondent, 25, I am appellant.
Okay, on request.
My
made
lord,
by-
one more thing, my lord. The case has not, both the case has not been admitted, my. It has to be heard on admission, my, not hearing.
It's not admitted.
Not admitted. I have checked, my lord. It is not a case to be admitted, my lord, because they did not challenge the parent order, my lord. Subsequent order they came, my lord, which cannot be. I have checked, my lord, in the net, my lord, in both the cases. Both, my lord, only. That one also I have checked from the net. Only notice was issued.
How much time do you want?
Six.
Okay, from the records
6th of February.
of both the writ appeals, we find that both the writ appeals have not been admitted till date. Stop. Accordingly, list this matter for admission on 6th February.
My lord, I am appearing a private respondent, my lord, that.
Mr. Jai Barboya, Learned Counsel, appears for respond number 4 in
First writ appeal.
writ appeal 246 of 2022.
All blessed.
May please your lordship, in item number 23, I was in other court, my lord. So that was fixed on after 2 weeks, my lord. My name has appeared as a non-appear, my lord. So my item number 23, my lord.
Item 23, okay.
I'm for the appealant, my lord.
Okay, on request made by MS.
A Gayan, my lord.
Yeah, Learned Counsel, Learned CGC,
Yes, my lord.
list after 2 weeks.
Master bless.
Item 26.
May I please? Issue in, yes. If issue involved in this video is connected with item number 6 and 7 of the today's list. This matter is fixed on Monday, lordship. Only 6 and 7 of today's list. Monday.
This is fixed on what, 6 and 7, what?
29th, lordship.
29.
Lordship.
Okay, you have Mr.
Yes, doctor.
On request made by S. Dutta, Learned Counsel,
On behalf of the revenue department.
Learned Standing Counsel.
Standing Council, revenue department.
Huh?
Revenue department.
You are the Standing Counsel?
Yes, boss.
On request made by S. Dutta, Learned Standing Counsel, Revenue Department. List on 29.
29. Problem.
Item 28.
Please, your lordships. Well, I'll pray for a very short order. In this requisition, a notification by which Assam Civil Service Rules 1998 was amended, that has been under challenge. Now, my lord, why, on the strength of that, my lord, the amendment, the Assam Tax Officers Association is before your lordship. One post was created above these technical officers as the additional principal secretary, additional commissioner of taxes. So we were agreed by that. He said that we are technical people and some bureaucrat will be, some IS officer will be put, and that will not be in the interest of the department also, in the interest of the revenue also. Now, my lord, although this amendment came in 2015, till now, my lord, it has not been implemented. And understandably, because of the fact that at that point of time, GST was not there. After the GST came into being, perhaps, my lord, the government thought that it will not be required to implement that. The petitioners were agree by the fact that there was a proposal in all the departments for restructuring of the departments, and proposals were made, inquiries were made, and thereafter some proposals were pending for restructuring by extending the strength of the cadres. Now, my prayer before lordship will be that, my lord, I'll not be pressing for the setting aside the rules, because, my lord, that has not been given effect to. My prayer is that there is a representation pending that may be directed to be considered. There, my lord, and entire grievance of the association members are there. That may be directed to be, my lord, disposed of by speaking order. That is the only limited prayer.
To that extent, I have no objection. They will consider the representation by passing a speaking order.
Who is the representative?
That your lordship will find at page 97.
97.
Representation dimly complain na lage na. Nothing to representation dimly complain. Na lage.
So we can just say that to consider.
Yes. Consider and pass an order.
But lordship may direct the respondent number 1 and 4. They will consider the representation and.
But it is addressed to one only.
It is addressed to 1. But the amendment lordship will find at page 92, the 92, lordship will see the additional chief secretary to the government of Assam personnel department. They have issued this. Ultimately, the relevant records are with the personnel department and the chief secretary they have addressed. Both of them, they will, in consultation, they will put.
Page 90?
92, I am referring to the gazette notification, the last portion, last part. It is under the signature of the additional chief secretary to the government of Assam personnel department. This is impugn that they have challenged this. So in consultation with the chief secretary and the respondent number 4, they will consider the filing.
Or maybe your lordship may direct that we will file a fresh representation before the respondent number 3. Respondent number 4.
It will be 4.
Because, my lord, he is saying that this is not addressed, this is addressed to the chief secretary, but the grievance will be considered by respondent number 4, the principal secretary personnel. So either your lordship may direct that this representation may be considered by him, the respondent number 4, or your lordship may give us liberty to file a fresh representation to the respondent.
Maybe a fresh representation may be better for you. Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr.
G. Vaishya.
G. Vaishya, learned counsel for the petitioners, isn't it?
My
It's a writ petition.
Yes,
So-
two petitioners, my lord.
Mm. For the petitioners, stop.
Very clear.
The present writ petition has been filed challenging the amendment made to the rules of Assam Civil Service Rules, Assam Civil Service Rules
1998
1998
by a notification dated 29/9/2015.
by notification dated 29/9/2015, wherein a new post of Senior Additional Commissioner of Taxes, correct,
My
has
I'll-
been created in the Taxation Department in Schedule 1 under Rule 3 within bracket 2. Stop. Let the senior counsel for the petitioner submits that despite amendment of the rules, amendment of the Assam Civil Service Rules 1998, the same has not been has not been implemented till date. And stop. He also submits that the petitioners association, this association, the petitioners association has filed a representation on 9/11/2015 addressed to the Chief Secretary to the Government of Assam with regard to the amendment of the Assam Civil Service Rules 1998. Stop. Should I say that you submit? The senior counsel submits that without entering into the merits of the present writ petition, without entering into the merits, writ petition may be disposed of by directing the petitioners association to file a detailed representation before the
Resolution
respond number 1.
Resolution
1 also,
4.
isn't it?
It will be resolution 4. Resolution 4.
Only 4.
Yes, my lord. That is what my lord.
Is it 1 and 4?
One and
One and
one and four. Let it be one and four.
Before the respondent number 1, oblique, the Chief Secretary to the Government of Assam, and respond number 4, oblique, the Principal Secretary to the Government of Assam, Department of Personnel, within bracket Personnel A. What did they say? Maybe disposed of. Okay, para. Recording the submission made by the learned senior counsel for the petitioners, this writ petition is disposed of, directing the petitioners association to file a detailed representation before the respond number 1 and 4 within a period of
15 days.
15 days from today.
Right.
From today. Stop. Thereafter, on receipt of the representation to be filed by the petitioners association, the respond number 1 and 4 shall consider the same and shall consider and dispose of the same by a speaking order and in accordance with law within a period of
1 month. Huh?
2 months.
2 months.
within 2 months
2 months.
from the date of receipt of the representation with the opposite observations and corrections.
Highly obliged.
No, I appear for FNO 1 and
Oh,
4.
sorry.
1 and 4.
Mr. D. Nath, Senior Government Advocate, appears for respondents 1 and 2.
Time being item 3 for admission.
I beg apology, Lordship. Yeah, matter is going on, Lordship. Lordship, may pass it for a day or two, Lordship.
Lord, it is extremely urgent. The client has almost misbehaved with me yesterday night. Because Lord, he is hanging. Oh, I have taken charge. I was transferred duly. As per the government admission.
Lordship,
And he occupied the chair forcefully, my lord, before the passing of the interim order by this court. And he is hanging on. He is not allowing me to work. I am hanging nowhere.
No, Lordship, he is already got the posting, Lordship. He's
Posting I
also got the
for
salary
his-
also, Lordship.
I've got a salary, all right, but I should have to.
He's
My
got the
entire record
posting also, Lordship.
transfer me, turn over to
Lordship,
Longding.
we have filed our affidavit in opposition, Lordship. He
That
has
is
already
true.
got the posting, Lordship.
हाँ, posting होती. हाँ.
कौन लिखा थे?
No,
Letter. He has
I've got
already
a
got the
po-
posting, Lordship. May kindly
I've got
take
a
up the
post, I've got
affidavit
the
in
posting
opposition,
only
Lordship.
Longding itself. But he is.
So are you arguing the matter today
No,
or not?
Lordship, he is he is on
Because
legs, Lordship.
it
Who's
was
on
they
legs?
who fixed the matter.
HK
Told
Das,
Maria is also
Lordship.
better.
Court number 13, Lordship.
No, who is appealing?
HK Das.
He is the petitioner's, he is the appellant.
Yes, Lordship.
You are the respondent.
Yes.
In IA,
Whatever.
he is the appellant, petitioner.
So when do you want?
Lordship, may fix it.
Both
Court number 13.
After again, there will be model code of contact and they will hang on it will pass over the time. Actually, number of days lost one is the note, ordership. Number of days are taken by him. Number of days. And today was fixed at their prayer. Entire, instead of hearing the IM filed by me, entire request heard was their prayer.
So when do you want?
Lordship may take it up on a hearing day, Lordship, February 6th, Lordship.
Then it will be infraction alert.
No, Lordship. He will retire on June, Lordship, not in practice, Lordship.
No.
February 6th.
If he is retiring in June, it will be infectious.
On request made on behalf of Mr.
10 customer.
It based on my.
HK Das,
Yes, Lord.
Leonard Counsel for the appellant, list on 6th of February.
Alert, can it be on Monday, my lord? For me at least. I am accommodating for 3 days.
No, Lordship, in a hearing day, Lordship, the matter can be heard, Lordship, since pleadings are
Well, last
complete
week
also,
uh,
Lordship.
my lord, it is not only 12 months, you are lost to finish the list. You are lost to can hear it. On Monday also. Monday, my lord.
On 6th, Lordship. 6th,
Monday,
Lordship.
Monday.
6.
Lordship.
He's saying 6. If we fix it
Lordship,
on Monday
other-
also,
other
then
matter
come
is
in
also
agenda.
fixed, Lordship. On 6th,
30th,
Lordship.
30th, Tuesday.
No, Lordship, he will be out of session, Lordship, on 30, Lordship.
That's why, my lord, let them
30
say
and
that
1, Lordship.
they
Then second,
Lordship, second.
second, list the matter on second.
Lordship, in
Mr. R.P. Shamal and
No further adjournment, they will seek, my lord.
appears for the respondent. Stop. You are appearing for the respond number?
3 man.
Respond number 3. Stop. It is made clear there shall be no adjournment on the next day.
Yes.
Mr. B.D. Goswami and additional advocate general appears for the state of Arunachal Pradesh.
Lordship, in this matter, interim order is here to into it.
Interim order partially to continue till the next.
Deeply obliged, Lord.
Just one more item, I think. Let's finish. Finish.
Lordship, my senior is out of session, Lordship, we have some difficulty today.
Who's your senior?
PD Nair, Lordship.
Yes, Bator. J. Bator, Leonard Counsel for the review petition on request made on behalf of Mr. P.J. Nair, Leonard Counsel for the respondents.
Exception number 6, Lordship.
Respond number 6. List when?
After 15th of February, Lordship.
List after 3 weeks.
Of the Lordship.
Lordship, can a date be fixed, my lord?
Can the date fix? Okay. 20.
Deeply obliged.
Oh, so many reviews.
Might have lost him. You must kindly see the order dated 7/8/23.
7/8/23. What is that?
Lord, I have received an instruction, Lord.
আমরা petition to give. আমরা একটা file করছি।
Well, the proposal has been sent, my lord. For the financial sanction, it is pending for payment of salary. Some time will be required. Some time is required, Lord.
The revised.
Yes, but that's
Revised.
only revised
Yes.
with effect from 16 as
Lot.
per ROP 17.
So there's a sanction
Yes.
amount.
Oh, no,
So
matter
let-
they are
let-
getting regular pay scale as per the RDR one. In the meantime, it was revised, that was not given to us.
But I'll get the detailed instruction, but they have informed that the amount has been sanctioned. It is under process, my lord, they will be
That-
paid. But
well,
let me have the detailed instruction.
Yes,
And
madam.
in the meantime, this amount, they are going to clear.
Current salary we are not getting, madam. That may be continued.
That was the order of the honorable court. Lord.
Yes, current, we are not getting till today, madam, for last
It is under process.
current salary.
Heard Mr. H.R.A. Chowdhury, London Senior Counsel for the review petitioners. Mr. D. Nath Leonard, Senior Governor Advocate, submits that the proposal for sanction of rupees 16,04,585 has been submitted, and the salary will be paid to the petitioners at an early date. He therefore prays for some time. Stop. Prayer is allowed. List after
My lord,
2 weeks.
let it be in the third week. On 21st or
We
21st.
fixed one on 20, isn't it? Yeah.
Lot.
List on 20.
Madam.
Madam, only in the current salary, madam, we are not getting, madam. That is a revised skill, another thing, a current salary, madam. That may be, madam, we are not getting the current salary. For since
Current salary,
The
current salary will not.
salary proposal has been sent here. Lord.
let us see what happens.
Published.
But in this review petition, kindly, Lordship, I have received the records, my lord. Lord, I need little accommodation here. Kindly give me some time, Lord. I have received the records, and there is a connected contempt case, Lord. The order reveals that the petitioner is supposed to, the contempt petitioner in the contempt petition is supposed to take some the steps for implement.
In the contempt.
In the,
Yes, that has not been
that
listed.
has not been listed.
Let it be listed.
Let it come up.
Lot.
Let the contempt come up.
My lord,
No.
Okay.
Both are
Yeah.
connected, Lordship.
Contempt for single bench.
No,
No,
Lordship, here.
here,
only.
here.
Before this,
Before this went.
before this division mentioned.
Okay, Mr. D. Nath Leonard, Senior Governor Advocate. Prays for some accommodation in matter today. Stop. When?
Let it be.
Same date.
Same
Yes,
date.
Lordship.
List on 20.
Obliged, Lordship.
May it please the Lordship.
Hmm.
There is a review petition, my lord, of the order at page 20. In substance, basically we're praying for consideration of a point which is an error referent on the face of the record. The case was whether we are entitled to VRS or not. There's a committee of 240 persons odd members. Now, the stand taken by the other side was that our members had resigned prior to that, and therefore, obviously, there's no question of any VRS. The error apparent on the face of the record, which we are canvassing with all respect, is that we had 240 members, 105 had resigned. So therefore, non-consideration of en bloc is a subject of review, my lord, number one. And number two, for the remaining part, the resignations were not even accepted in terms of law. And the third part, which we're canvassing, is that
Is it coming up for the first time today?
first time, my lord. I'll pay for notice
No,
at the moment, my lord.
Yes. First time. No issue notice. But it's money for the council for the review petition. Issue notice. Who are the respondents?
Lordship, Industries and Commerce Department is the main respondent, but their name is not reflected in the cause list.
MS.
Lordship, A. Kalita is standing counsel by Industries and Commerce Department. Their name may be reflected in the cause list.
Industries and Commerce.
Lordship,
And you are paying for?
I'm only for two. Lordship, two and also they will appear, will not appear.
So you are
Industries
not,
Department.
so you are not appearing.
Mal-
The council for the review petitioner shall furnish appropriate copies to the Learned Standing Council, Industries and Commerce Department
Lordship.
within the course of the day. When do you want? List down after?
I presume the notice, the copy was served, only name was not reflected, indicated in the pause list.
Kalita, you have served copies.
Obviously, Milord, otherwise the matter would not have been listed.
They have served copy to the government. We have record.
You have served to the government.
Yes,
So
ma'am.
you have not served to the Standing Council. Registry is also directed to reflect the name of the Standing Council, Industries and Commerce in the cost list. List on,
Anything.
same date will go to 20.
Obliged, my lord. May it please your lordship, on last occasion, this honorable court has directed us to take instruction regarding the name of the petitioner, Madam my lord. We have received. It's the same person. Today morning, lordship, we have received instruction.
Where's the order? Where's the order of this court?
Lordship,
1812.
18/12/2020.
Page.
Page.
Is it? Yeah. So you'll have to file an affidavit as per the early order.
Lordship, today morning only we have received the instruction, but Lordship, the earlier affidavit, my lord, may kindly have a look. Page 20, internal page. We have already filed one affidavit. Page 20, internal page, my
No,
lord.
but you'll have to submit a report by way of an affidavit. That
That
is the
report
order.
is annexed already, the police report.
Subsequently, there is an order around 1812.
Yes, that instruction we can file in the
That's
common
why you are
report.
directed to file a clarification
Lordship,
affidavit.
then Lordship may kindly give us some time.
At times meet learned counsel for the applicants. MS,
MD Bora,
MB Bora, then it's.
government.
It's allowed how much time?
Lordship, 1 week time. my lord.
1 week time to file a clarificatory affidavit. Stop. List after 1 week. Oh, we'll fix it. We'll list it on the same day, list on 20.
February, my lord.
20.
Lordship, deeply obliged. Lord.
Matter came last week, my lord, and FCI's counsel, Mr. Roy was not there. I gave a copy of the solvency certificate. My lord, the matter to refresh your lordship, matter is simply like the writ appeal was withdrawn by them. My lord, the tender was floated by FCI in way back in 2015, mentioning the distance 178 kilometers. In the work order, distance is mentioned. We completed 2017, my lord. All dues were paid to me, bills and all. So contract actually virtually came to an end. 5 years thereafter, my lord, FCI, my lord, unilaterally deducted money from my other contracts, saying that no, in that contract it was 6 kilometers less. Now, my lord, single just declared it to be arbitrary and set aside the recovery order. And my lord, directed them to pay within 2 months. And it was, my lord, the case that you floated the tender, you invited the people, come, it is 170 odd kilometer, you file a tender. Clearly distance is mentioned. Had you mentioned that no, it is not 170 kilometer, it is 160 kilometer, we would have quoted different rate, my lord. That is also one reason. Then it was set aside and lordship will find your order, your lordship. Learned single judge's order, my lord, in my eye I have annexed. At my lord, page 50, Kiman, আমার আয়াত, page Kiman. Judgment, my lord, in the main read. Page 38. Page 38 says on here. In the writ appeal, in the, my lord, writ appeal, your lordship will find, writ appeal is there. Single judge's judgment is there. Page. Page 39 of the writ appeal, my lord, learned single judge judgment.
Writ appeal?
Writ appeal, my lord. Correct, where na? Come to detail. Page 39. What is it? Judgment, your lordship will find it. Page 133. I'm sorry, lord.
It's available in your IA, a review petition.
Review petition, my lord, there. Subsequent order is there. The writ appeal was filed by them. And
Writ appeal order is also there.
writ appeal order, my lord, in the writ appeal, it is operative portion your lordship will find that, my lord. Page 150, paragraph 39. After discussing, my lord, in detail, for the reasons aforementioned, we are of the view that the impugned recovery made by respondent FCI pursuant to communication dated 2020. I finished the work in 2015, as well as office note, internal office note, amounting to rupees, recovery of amounting to rupees 89.9 lakhs from contractor's bill is held to be arbitrary, unreasonable, unsustainable in law, and accordingly same stand set aside. Amount that had already been recovered
You
from
are
the
referring to the writ appeal order.
writ appeal, my lord.
Writ appeal number 385.
Yes, my lord.
What is the date of the judgment and order?
Writ appeal number 385, my lord. It starts at, my lord, page 1. Page 134, my lord.
Date of the judgment.
Date
Date.
3/11/22.
Can you come to your
Writ petition, my lord. This is the writ appeal, memo of appeal. This thing is learned single judges.
You are referring to the writ petition judgment or writ appeal judgment?
Writ petition judgment.
Writ petition.
That is-
So
that
we are
is-
referring to the writ appeal judgment.
No. Writ appeal was withdrawn later on. I'll come to that. 133, the judgment starts, my lord. And my lord, operative portion is at page 150. It's a long judgment. Paragraph 39. Yes. For the reasons mentioned above, we are of the view that impugned recovery made by respondent FCI pursuant to the communication dated 20, works finished in 2015. So and so, as well as internal office note, manager contact amounting to rupees, recovery amounting 89 and odd from contractor's bill of the petitioner is held to be arbitrary, unreasonable, unsuitable, unsustainable in law, and accordingly same stands set aside. Amount that had already been recovered from the petitioner contractor shall be refunded back to the petitioner within a period of 3 months from the date of this. This was the, my lord, judgment. Then, my lord, the FCI filed a writ appeal. In the writ appeal, my lord, the order your lordship will file in my IA, my lord. Page 19. Page 19, my lord. They referred to, my lord, it was virtually a review petition, my lord, in the name of an IA. And therefore, after discussion, lordship may come to page 22. Be that discuss the facts, my lord. Be that as it may, during the course of the hearing, learned counsel appearing for FCI submitted that he would like to withdraw the appeal, seeking liberty of this court to approach the appropriate forum. It may be civil court, it may be any other forum, my lord, including the grievance committee. Upon such submissions by the learned senior counsel for the appellant, we permit the appellants to withdraw the appeal and approach the competent forum as per provisions of law. Findings of the learned single judge will not be a hurdle in approaching the relevant or competent forum as deemed may be. This court doesn't say which forum. Appropriate under the provisions of law. In view of the withdrawal of the present appeal, however, the directions of the learned single judge for release of the payment shall be complied. So this was the direction. There the matter ought to be ended. And then, my lord, the FCI file and IA, being IA number 6398, my lord, praying for some more leverage. That order is at page 31, no? Right. Page 30.
I think it
No.
begins at page 40.
No. Our application, my lord, it is at page 12. It was there. My lord, page 12.
14.
No, it is. It is. Page 12. Here, page, your lordship will. Yes. Undertaking. It talk about giving an undertaking by me. My lord, I had 2527. In our latest. Page 12. No. Page 12. Here, my lord, paragraph 9. In view of such directions being made at 17, and upon hearing learned counsel party, this court is of the view and substantially application disposed directing the FCI to release the amount due to the petitioner as directed as per single judge order, read with order dated so and so within a period of 30 days date of receipt. Respondent shall also furnishes. Here, my lord, the problem arose. Solvency. Actually, my lord, frankly speaking, my learned friend also prayed that some undertaking should be given. I'm sure he will be fair enough. Some undertaking talking about. In the petitions, the word was there. Now, therefore, solvency was the condition. Now, my lord, it will be like I inquired about solvency. It is too cumbersome. Solvency, and there is actually no forum. And solvency, my lord, per lakhs, certain several thousand, my lord, 6,000-7,000 are deducted, and that is open end, my lord. That is not for a indefinite period. That will neither serve FCI's purpose nor serve our purpose. And bank nowadays, my lord, issue only this sort of certificate which I gave that day. That day it was also came. My lord, one thing. This is in future, if they can lawfully, they have a lawful decree or order by competent court of law, and I will be at my liberty to, my lord, to contest that such claim. Now, my lord, before such things, if I am made to pay a huge amount as a commission or charges to the bank, now talking about bank guarantee, that your lordship asked me,
May please your lordship, sir. Lordship, before the learned advocate general starts, we have just one additional submission in the next, in continuation with what was argued on the last occasion by my learned senior counsel, Mr. Chaudhary.
Brother, do you want to continue with the single bench or? Brother, few minutes. Mr. Goswami,
Yes, Lordship.
today we're having some problems. So we can fix a different date instead of today.
Whatever convenient. Can it be on Monday?
Yes, Lordship.
Monday?
Monday, Lordship, a lot of other cases were fixed. Could it be on Tuesday, Lordship?
Yeah, Tuesday can go.
Tuesday, no, whatever.
Tuesday will be 30th, 30.
You can take your convenient dates.
I just. Oh. We preparado. Lordship.
Okay. From 5th to 16th, one of us will not be here.
If to 16th. And first and second, I am not there. Otherwise, I am available.
From 5th to 16th, one of us are not there.
Then 19th.
19th you are available.
Let it be on, since I've come, then let it be on 30th. That's
30.
30. Okay.
Or if Lordship can take up the matter on, if it is coming on the
29th.
second half only. So Monday also.
29th.
Because I will take 2 days for 29th and 30.
Let it come up on 29th and if required, then we'll.
Monday there's some quite a lot of
Lordship,
letters.
then 30th, 30.
Can it be a little high up on the board, Lordship, subject to Lordship's convenience on
It's a
30th?
parted matter, it will come up higher.
It is a special matter.
We can have it at 2?
Lordship.
At 2 on Tuesday?
No difficulty, Lord.
Heard Mr. M. Goswami, learned counsel for the petitioners, as well as Mr. D. Saikel, learned Advocate General Assam. Also heard Mr. R.K.D. Chowdhury, learned Deputy Solicitor General of India for the Union of India, and Mr. S.R. Raba, learned Standing Counsel for the BTC. Stop. List the matter again on 30 January as parted. At 2 p.m.
Although the pair number 2 people.